Good afternoon, everybody. Welcome again to the 30th Annual MCLE Spectacular. I'm David Pearson, the Contra Costa County Bar President for, another 6 weeks, Sarah? Yay. And I want to now introduce the Honorable Jeffrey Brand. He has decades of legal experience as a judge, civil litigation practitioner, and dean of the University of San Francisco School of Law. He served on the Alameda County Superior Court for over 9 years, chairing the ADR Resolution Committee and supervising the General Civil Department. Before his judicial appointment, he was the dean of the University of San Francisco School of Law for 14 years and a professor of law. As an attorney, he focused on labor and employment law and served as general counsel for the Reno Silver Sox. Judge Brand is known for his fair approach, diligent preparation, and ability to resolve cases creatively. The Honorable Judge Brand will be speaking briefly about JAMS, a longtime partner and our friend, and this year's event benefactor sponsor. He's also going to be introducing our keynote speaker, which I am dying to hear his speech today after our last election. So, come up, Judge Brand.
Yes, looking at the slide, the title is, I think, particularly apt for today, so I'm looking forward to hear Dean Chemerinsky's remarks. I do want to welcome everybody on behalf of JAMS. I've just begun my own work there as a mediator, having recently retired. And I think what we do as judges and what we try to do at JAMS is particularly important now, to get people talking to each other, to make facts something that we focus on in hoping to reach fair resolutions, whether it be in the courtroom or in mediation or in arbitration. So on behalf of JAMS, I'm very proud to be here. I'm particularly proud to introduce Dean Chemerinsky, who I've known for a long time, and I will abide Erwin's request for a relatively short introduction, but I do want to make one point in particular, which I think will be apparent when I get to it. It's a pleasure to introduce Dean Chemerinsky, who has served as the 13th Dean of Berkeley Law since 2017, when he joined the faculty as the Jesse Chopra Distinguished Professor of Law. Truly one of the great constitutional scholars, as Erwin has become himself. Dean Chemerinsky hails from the south side of Chicago, attended Northwestern University as an undergrad, and then graduated from the Harvard Law School, where he graduated cum laude in 1978. After law school, Dean Chemerinsky joined the Department of Justice, followed by a stint in private practice, before beginning his storied career in legal education, a journey which has taken him from the DePaul College of Law to USC, to Duke, and to his first deanship at the University of California at Irvine, where he was appointed the founding dean and the Raymond Perrick Distinguished Professor of Law. And of course, at Irvine, helped to create, along with his staff and faculty, another distinguished University of California law school. But I will say this, that a mere recitation of Dean Chemerinsky's resume and journey does not really give us a sense of his impact on legal education and on the profession through his scholarship, his writing, his teaching, his advocacy, and engagement. And the numbers are staggering, including hundreds of law review articles, tens of books, one of which is shown on the slide, and copies are here today. and dozens of op-ed pieces, which I suspect many of us have read, and also frequently arguing cases before appellate courts all over the country, including the United States Supreme Court. But what I do want to emphasize is that to many, Dean Chemerinsky is the North Star as we try to navigate the constitutional thicket in these fraught times. And for those of us who have been involved in legal education, his emphasis on the need for clinical education and continuing to teach despite his responsibilities really becomes the standard by which we do our work. Dean Chemerinsky reminds us of the responsibility of law schools to train skilled, ethical professionals. And no wonder National Jurist magazine just this year found Dean Chemerinsky the most influential person in legal education in the United States. So don't just take it from me. I did consult with a former faculty member of Dean Chemerinsky's before this talk, and he noted to me that Dean Chemerinsky is noted for sleeping little and doing much. And he provided an anecdote that I think is worth very briefly sharing. He writes, I once asked Erwin on the spur of the moment to summarize the Supreme Court's most recent term at an orientation lunch for incoming students. He did it without so much as a note, and after the lunch provided the students a brief handout with the names of the cases and the lists of the issues. I found all this very impressive, but it became even more clear to me after Erwin left Irvine. When I put on the Supreme Court preview in the following years, I had to enlist 4 faculty members to perform the same task to cover the full range of topics. Indeed, we're honored to have Dean Chemerinsky with us today. Dean.
Wow, so incredibly kind of you. It's truly my great honor and pleasure to be with you. No form of government lasts forever. No democracy lasts forever. There are countries around the world that were democracies but aren't anymore. This is not a political statement about the results of the Tuesday election. This was the title of my talk chosen months ago. It's the title of a book that was published in August that went to the printer well over a year ago. It's the same talk I would have given to you no matter what the outcome of the Tuesday election. The premise in my book is that I believe there's a serious crisis facing American democracy. American government has lost the faith of the people. There was a survey that was done this past summer, and the approval rating for Congress was 16, and that might be 16 people, not 16%. Again, we have a president with approval ratings in the 30s. The Supreme Court has its lowest approval rating in American history. A Quinnipiac University poll that was taken had 30% expressing approval for the Supreme Court and 59% expressing disapproval. A Gallup poll said only 25% of those surveyed expressed confidence in the United States Supreme Court. Our society is more deeply polarized than it's been at any time since Reconstruction. One measure that political scientists use with regard to polarization is the difference between approval of a president from his party compared to the other party. When Donald Trump was president, the approval rating among Republicans was 89%. The approval rating among Democrats was 7%. That's the largest gap in American history. The second largest gap is now with Joe Biden as president. And if there's anything that we can draw as a conclusion from Tuesday's election, maybe the same conclusion, or who won? So very deeply polarized the American people are. There's so little agreement about basic values, let alone issues. And the question that I pose for you today is, can a government survive? Can democracy survive under those circumstances? It's interesting, in writing this book, and I say this in conclusion, it's strange to begin with a premise that I hope is wrong. I hope there's not a crisis facing American democracy. I hope that Donald Trump will be a president who will somehow unify the country. But if he's a president who further divides us, then the crisis of democracy that I'm speaking at becomes even more acute. I decided to write this book after January 6th, and it wasn't about the insurrection itself, but it was the belief that the insurrection that occurred there reflected deep problems in our country. And so what I set out to do in the book was try to figure out, why is there a crisis facing American democracy? And then, what solutions are possible? The premise of my book is that choices that were made in drafting the Constitution in 1787 were mistakes then. They were necessary mistakes. The Constitution wouldn't have been ratified without them. But they become much more salient in recent years. And choices that are made along the way exacerbate those problems. Think about the institutions created by the Constitution. One is, of course, the presidency. The Constitution has the president chosen by the Electoral College. This was a terrible way of choosing the president in 1787, and it's a terrible way of choosing the president today. In a democracy, the person who gets the most votes should be the person who's elected. Yet twice in this century, in 2000 and 2016, the candidate who lost the popular vote became president because of the Electoral College. It almost happened 2 other times. In 2004, if John Kerry had won the state of Ohio, he would have been president despite losing the popular vote. In 2020, if 42,000 votes had come out differently in 3 states, Donald Trump would have won his second term then. Looking at the Electoral College, the mistake isn't just about hindsight. If you look at why it was adopted, in large part it was based on a distrust of the people. Alexander Hamilton, in the Federalist Papers, written to try to persuade people in New York to ratify the Constitution, said that the elites who are informed should choose the president. The framers didn't want the masses to choose the president. Also, the Electoral College was adopted very much to protect and enhance the political strength of southern states with enslaved populations. Slaves, of course, could not vote, but southern states still wanted political strength from their enslaved population. Prior to the time that the Constitutional Convention considered the Electoral College, they'd adopted the 3/5 clause. This essentially provided that enslaved individuals would count as 3/5 of a person in allocating seats in the House of Representatives. The number of electors that a state gets is the sum of its senators and its representatives. Southern states then gained tremendous political advantage by virtue of the Electoral College because they got the benefit of their enslaved populations being counted in allocating seats in the House. This, too, is not just hindsight. At the Constitutional Convention, Hugh Williamson, a delegate from North Carolina, praised the Electoral College precisely because of the way in which it would enhance the political strength of southern states. None other than James Madison, a delegate from Virginia to the Constitutional Convention, did exactly the same thing. We should be troubled, if not embarrassed, by an institution that chooses presidents based on a desire to try to enhance the political power of southern states. And it worked. Virtually every president elected in the first half century of American history was in the South, often precisely because of the benefits of the enslaved populations. The Electoral College didn't matter in the 20th century. There was no instance in the 20th century where the loser of the popular vote became president because of the Electoral College. But population shifts and partisan realignment make it quite likely will continue to happen in the 21st century. It didn't happen Tuesday, but we weren't far from it happening. It wouldn't have taken many popular votes to shift for Donald Trump to be the loser in the popular vote, but again prevail in the Electoral College. Think of another institution created by the Constitution, the United States Senate. One of the choices that was essential in creating the Constitution was equal representation among the states in the United States Senate. 2 senators per state. This resulted from a dispute between the larger states that wanted representation allocated based on population and the smaller states that wanted equal representation. So there was a compromise. The House of Representatives would be allocated based on population, but the Senate have equal representation. At the time of the Constitutional Convention, the difference between the most populous state, Virginia, and the least populous state, Delaware, was 12-1. Today, the difference between the most populous state, California, and the least populous state, Wyoming, is 88-1. Present the statistic to you in another way. In the last session of Congress, there were an equal number of Democratic and Republican senators. But the 50 Democratic senators represented 42 million more people than the 50 Republican senators. This, of course, also increases the problems of the Electoral College, because again, every state's electors is the sum of its representatives and senators. The problems of the Senate were made much worse when the rules for the filibuster changed. Now, my guess is for most of us in this room, our image of the filibuster is Jimmy Stewart in Mr. Smith Goes to Washington, holding the podium in the Senate until he literally collapsed from exhaustion while fighting corruption. But in the 1970s, the Senate changed its rules with regard to the filibuster. Now, no longer does a senator have to hold the floor. All that's required is an indication of a desire to filibuster. And then the Senate will continue with all of its other business until and unless there's 60 votes for cloture to end the filibuster. The result is, except for budget matters and appointments of federal judges and cabinet members, everything else takes 60 votes to pass through the Senate. The result is how much more difficult it is to adopt legislation than the framers of the Constitution could have ever envisioned. Third part of government that's created by the Constitution is the House of Representatives. This is the one part of federal government established in the Constitution that is supposed to be directly representative of the people. Because remember, the Electoral College chooses the president. At the time the Constitution was written, in many states, it was the state legislatures that chose the electors, not popular vote. When the Constitution was written, senators were chosen by state legislatures, not by the people. The House of Representatives is the only part of the federal government, when the Constitution was written, chosen by the people. And yet here, democracy has been undermined by partisan gerrymandering. Partisan gerrymandering is where the political party that controls the legislature draws election districts to maximize, say, seats for that party. It's where, say, a Republican-controlled legislature draws election districts to maximize state seats for Republicans, or a Democratic-controlled city council draws city council districts to maximize, say, seats for Democrats. Partisan gerrymandering is nothing new. It takes its name from a governor in Massachusetts early in American history, Elbridge Gerry. He drew districts in a way that looked like a salamander, and a newspaper coined the phrase gerrymandering. and it's stuck ever since. But what's changed is sophisticated computer programs made it possible for legislatures to engage in partisan gerrymandering with far more precision than ever before. As Justice Elena Kagan said in a dissenting opinion, this is not your grandparents' partisan gerrymandering. Takes an example, the state of North Carolina. It was the focus for the Supreme Court case about partisan gerrymandering, Rucho versus Common Cause in 2019. North Carolina is a purple state. It went for Obama in 2008, Romney in 2012, and then for Trump in the last three elections, but always very close. In 2020, Trump beat Biden in North Carolina by 1.35%. After Republicans gained control of the North Carolina state legislature, they engaged in gerrymandering. At the time, there were 13 congressional seats from North Carolina. And the leaders of the Republican Party were open about what they're trying to do. They said their goal was to give Republicans control of 10 of 13 seats from North Carolina in the House of Representatives. They said they would go for even more if they could draw maps to do so. They had a computer draw 3,000 different maps for how election districts might be drawn for congressional seats in North Carolina. They picked the one most likely to let Republicans win 10 of 13 seats. It should surprise no one. It worked. In the 2016 and the 2018 elections, Democrats and Republicans statewide in North Carolina got almost exactly the same number of votes and seats for Congress, but Republicans won 10 of 13 seats. In 2022, the North Carolina Supreme Court found that the gerrymandering violated the North Carolina state constitution. It had a nonpartisan commission draw election districts for congressional seats in North Carolina. Again, it should surprise no one. Democrats won 7 seats and Republicans won 7 seats when it was done in a nonpartisan way. There was a shift in the political composition of the North Carolina Supreme Court in the 2022 election. The new court, with a 5-2 Republican majority, overruled the decision of the old court. And so partisan gerrymandering was in effect for Tuesday's election. It appears that Republicans won 10 of 14 seats now in Congress from North Carolina because of the effectiveness of partisan gerrymandering. Partisan gerrymandering is so inconsistent with the basic premises of democracy. Democracy is founded on the idea that it's the people who choose their elected representatives. Partisan gerrymandering allows elected representatives to choose their constituents. In 2019, in Rucho versus Common Cause, the Supreme Court held that federal courts cannot hear challenges to partisan gerrymandering. It doesn't matter how egregious or extreme, it can't be heard in the federal courts. The result is, in so many states, for state legislatures, for congressional districts, there's a tremendous disparity between the political composition of the state and the votes and who actually gets elected to office. Now, in California, we don't deal with that because California voters have created independent commissions, both for drawing state legislative districts and also congressional districts. But we are only one of a handful of states that does that. Well, the other part of the federal government created by the Constitution is the federal judiciary. Article 3, Section 1 says that there will be a Supreme Court and such inferior courts as Congress from time to time shall ordain and establish. I think another mistake that was done in drafting the Constitution was to give Supreme Court justices, and for that matter, lower federal court judges, life tenure. From 1787, when the Constitution was written, until 1970, the average tenure of a Supreme Court justice was 15 years. It was remarkably constant during all of that time. Since 1970, for those appointed to the court who have left the bench, their average tenure is 27 years. And that's growing all the time. Clarence Thomas was 43 years old when he was confirmed for the Supreme Court in 1991. If he remains on the court until he's 90, the age Justice John Paul Stevens retired, Thomas will be a Supreme Court justice for 47 years. I don't want this to sound partisan. Elena Kagan was 50 when she was confirmed for the court. If she stays until she's 90, that's 40 years. Amy Coney Barrett was 48 when she was confirmed for the Supreme Court 4 years ago. If she stays on the court until she's 87, the age at which the justice she replaced, Ruth Bader Ginsburg, died, Barrett will be a justice until the year 2059. All of this is just too much power in one person's hands for too long a period of time. Thankfully, life expectancy is a lot longer than it was in 1787, or anyone could have expected. In 1787, average life expectancy was 36 years. But there's another problem with the life tenure for Supreme Court justices. So much depends on the accident of history when vacancies occur. Between 1960 and 2020, there were 32 years with a Republican president and 32 years with a Democratic president. At the end of the Biden term, we'll have 32 years with a Democratic president and 32 years with a Republican president, even. But between 1960 and 2020, Republican presidents picked 15 justices and Democratic presidents picked only 8 justices, almost a 2-to-1 difference. Richard Nixon picked 4 justices in his first 2 years as president. Donald Trump picked 3 justices in his 4 years as president. On the other hand, Jimmy Carter picked no justices in his 4 years as president, and Joe Biden picked only 1. I can present the statistic to you in another way. Donald Trump picked 3 justices in 4 years. The prior 3 Democratic presidents, Jimmy Carter, Bill Clinton, Barack Obama, picked only 4 justices in 2 decades in the White House. I would strongly favor 18-year non-renewable terms for Supreme Court justices. 18 years is long enough to master the job, to succeed with regard to the learning curve, but it also keeps people from being there for 40 or even 50 years. It also means there'd be a vacancy every 2 years on the Supreme Court, giving every president, Republican and Democrat, equal influence. I think the decisions of the Supreme Court have also very much contributed to the crisis of democracy that's the premise of my talk and the premise of my book. In Shelby County versus Holder, on June 25, 2013, the Supreme Court declared unconstitutional a crucial provision of the Voting Rights Act of 1965. I regard the Voting Rights Act of 1965 as one of the most important federal laws adopted in my lifetime. Section 2 says that state and local governments cannot have election systems or practices that discriminate against voters of color or language minorities. But Congress knew from experience that just prohibiting discrimination and authorizing lawsuits wasn't enough. Do you remember the arcade game Whack-A-Mole, where you knock it down in one place and it pops up in another? That's what Congress saw going on, especially in southern states. So it added Section 5 of the 14th of the Voting Rights Act. Section 5 says, for jurisdictions with a history of race discrimination in voting, they would need to get pre-approval, pre-clearance for changing their election systems. These provisions were scheduled to expire in 2006. Congress held 16 different hearings and compiled a legislative record over 10,000 pages about the success of Section 5 of the Voting Rights Act. It documented almost 300 instances where state and local election practices were invalidated because of the discriminatory impact. It talked about likely thousands of others where states didn't try to put into effect discriminatory practices because they knew it would be denied pre-clearance. Congress voted overwhelmingly to extend the pre-clearance requirement of Section 5 of the Voting Rights Act. The vote in the Senate was 98-0. Can you imagine the Senate today doing anything, let alone something that might be controversial? 98-0. And there were only 30-some no votes in the House. President George W. Bush signed it into law. But in Shelby County versus Holder, the Supreme Court invalidated the requirement for preclearance. Chief Justice Roberts wrote to the court and said, it violates the principle of equal state sovereignty, that Congress has to treat all states the same. But where in the Constitution does it say that? If one wanted to follow the original intent, the same Congress that ratified the 14th Amendment voted for Reconstruction to impose military rule on southern states. Since 2013, no state has had to get preclearance for changing its election systems. As a result, from 1965 to 2013, there was a steady increase in black voter registration and black voter participation. Since 2013, it's gone down, which is the first time since the Voting Rights Act. And Justice Elena Kagan made the point in a recent dissenting opinion, is very much because of the end of preclearance. And I think few Supreme Court cases, all of American history, have been more corrosive of American democracy than that in Citizens United versus Federal Election Commission in 2010. There, the Supreme Court held that corporations can spend unlimited amounts of money out of their corporate treasuries to cast elected or defeated. Citizens United has bred enormous cynicism about our election system among the American people. And the effects of Citizens United are especially felt in more local elections. Political scientists have shown that it's the elections where the candidates that don't have name visibility that are most likely to be affected by campaign spending. And they can show, both with examples and overall, how much Citizens United has mattered in so many elections in affecting the outcome. All of these are ways in which the Supreme Court itself has contributed to the problem of democracy. The focus of my book and my talk is the mistakes that were made in drafting the Constitution that haunt us today. In talking about this, we can't ignore the tragic choices that were made with regard to race in drafting the Constitution. The Constitution very much protected the institution of slavery and the rights of those who owned enslaved people. For instance, one of the big debates of the Constitution was whether Congress would have the authority to ban the importation of additional enslaved individuals. North Carolina and South Carolina made clear that they would leave the Constitutional Convention if Congress had the power to ban further importation of enslaved individuals. The result was, it was put in the Constitution, that Congress could not ban importation of individuals for 20 years. And there are two provisions in the Constitution under Article 5 that can't be changed by amendment. And one of them is that provision. The other is equal representation of the states in the Senate. I mentioned already the 3/5 clause that treats enslaved individuals not as human beings, certainly not as voters, but as 3/5 of a person. And in Article 4, there is the fugitive slave clause that said that an enslaved individual escaped to a free state, that person had to be returned to his or her owner. I ask my students every year when I teach constitutional law that if they had been at the Constitutional Convention and they, like some, such as Benjamin Franklin, found slavery to be an abomination, a crime against humanity, would they have agreed to a constitution that protected slavery? Would it have been better for the United States to split into two or more separate countries than to accept a constitution that so protected the institution of slavery? I think those from the North who were abolitionists told themselves the story that slavery was on its way out and that soon it would stop existing as a practice. They, of course, were wrong. And from 1787 until 1865, Not one Supreme Court decision chipped away at the institution of slavery. Every Supreme Court case about slavery protected the rights of the owners of enslaved people. The choices that the framers made with regard to slavery and race have haunted us through American history and haunt us today in the tremendous racial inequalities that remain in our society. Finally, in terms of the problems that contribute to the crisis of democracy, we have to focus on something that's much more recent, that the framers in their wildest imaginations couldn't have dreamed of, and that's the internet and social media. The internet and social media are themselves contributing to the problems of democracy. False speech is pervasive over the internet, and we've yet to find a way consistent with the First Amendment of dealing with it. Additionally, there's the problem of foreign influence in elections, which was documented in 2016 and apparently occurred in this election as well. So what I've tried to suggest to you in these remarks is that there is a crisis facing democracy, and why. But I also want to suggest to you that all of the problems that I've referred to are solvable. I do not believe at all that the situation is hopeless for American democracy. If there is the will to change, it can be done. And I want to suggest to you reforms that can be done in many ways. But most of all, I'd argue that none of these reforms are partisan. None favor inherently Democrats or Republicans more than the other. Think about what I've suggested. Some of what I've talked about can be fixed by statutes or rule changes. You don't even need to fix the Constitution. Take the Electoral College as an example. Admittedly, eliminating the Electoral College would require a constitutional amendment. That would be difficult because it would take 2/3 of both houses of Congress and 3/4 of the states. Let me pause here and say I think another flaw in the Constitution is written. It was made far too difficult to change and amend. In fact, since 1791, when the Bill of Rights was adopted, there have only been 17 other amendments to the Constitution, and one was to create and others repeal prohibition. With regard to the Electoral College, I don't think we'll ever get 3/4 of the states to agree to eliminate it because enough states benefit from it, getting disproportionate political influence. They want to keep it. But there is a fix that could make the Electoral College much less likely to choose the loser of the popular vote. Require proportionate representation in the Electoral College from each state, proportion of the way the votes were cast in that state. As you know, all but Maine and Nebraska do winner take all. If you voted for Donald Trump in California on Tuesday, your vote doesn't matter at all. Kamala Harris will get all the electoral votes from California. Correspondingly, if I was in Texas, I could say, if you voted for Kamala Harris here, your vote doesn't matter at all. Donald Trump is going to get all the electoral votes. We wouldn't accept winner take all in virtually any other circumstance. Political scientists have documented that if there wasn't winner take all, it would be far less likely that the loser of the popular vote could win in the Electoral College. The problem is states on their own aren't going to eliminate winner take all. They're not going to engage in unilateral disarmament. California is not going to give some of its electors to Donald Trump if Texas isn't going to give some of its electors to Kamala Harris. The only way we can solve the problem is for Congress to act. And I believe that Congress has sufficient authority over elections that it could say that every state has to allocate its electors in a way that's proportionate to the popular vote. It wouldn't eliminate the Electoral College, but it would certainly decrease its impact. Another way of decreasing the impact of the Electoral College and the way it favors small states would be increase the size of the House of Representatives. The House of Representatives has been the current size ever since the 1920s. Think of how much population has grown since then. If we increase the size of the House of Representatives, there'd be more representation proportionally to more populous states, and again decrease the likelihood the Electoral College would choose someone who had lost the popular vote. Continuing with changes that can be done without needing a constitutional amendment. The Senate could change its rules with regard to the filibuster. The filibuster isn't created by the Constitution. It's not created by federal statute. It's created by Senate rules. And the Senate, as I said, had amended those rules in the 1970s to make it much easier for filibusters to occur. What would be one possibility? To say the first time it takes a vote to end the filibuster is 60 votes as now, the second time 55 votes, the third time a majority, 51 votes. It would still keep the filibuster's way of encouraging deliberation, but not eliminate it entirely. Or we could go back to what the rules were before the 1970s, talking filibusters, so that there's a cost to the filibuster occurring to make them far less likely. With regard to the House of Representatives, Congress could pass a law saying that there cannot be partisan gerrymandering for congressional seats, that every state would have to do what California does, have a commission to draw congressional districts, a commission that's nonpartisan, that doesn't give favoritism to one political party over the other. Also, states on their own could do what California has done and create nonpartisan commissions for drawing election districts. With regard to the Supreme Court, its decisions that have undermined democracy can often be overcome by statute. Congress could adopt a new Voting Rights Act to overcome the problems from Shelby County versus Holder. Indeed, in the last session of Congress, the House of Representatives passed such a bill, but it died in the Senate because of a Republican filibuster. Giving every person equal ability to vote shouldn't in any way be regarded as partisan. I think there's ways to fix the campaign finance system. For example, I think that there could be a law adopted at the federal level, the federal government, or at state and local levels, for state and local governments, that say that businesses that are contracting with that level of government cannot spend money for officials to be elected for that level of government. As some of you probably experience, if you go to work for the federal government, and you're in the civil service, you can't engage in partisan political activity. That's the Hatch Act. Can't we have a similar law with regard to corporations? Or at the very least, there can be much stricter disclosure laws. Congress, after Citizens United, passed, or at least the House of Representatives, the Disclose Act. Again, it died in the Senate because of a filibuster. The result has been the tremendous proliferation of dark money in politics. So we can't know where the money came from. There's no justification for this. The Supreme Court has repeatedly made clear that disclosure laws are constitutional because of the compelling interest in voters knowing where the money came from. With regard to race, our society can do so much more to advance civil rights. Think of how long it's been since there was a major law adopted to advance civil rights. 1992, 32 years ago. And so my point with regard to this is that without needing to amend the Constitution, so many of the problems I've identified could be fixed. But also, there can be constitutional amendments. Admittedly, it's very difficult, and yet it's not impossible. There was a decade, the second decade of the 20th century, where 4 amendments were adopted in a relatively short period of time. One gave women the right to vote. Another created popular election of senators. Another allowed the federal income tax, and the other was with regard to prohibition. But if there is the will, there's certainly the possibility for constitutional amendments to reform what I've said. Let me give you an example where I think there could be a successful constitutional amendment, and that would be for term limits for Supreme Court justices. Some have argued that we can have term limits just by federal statute. I'm skeptical of that. The Constitution says the justices of the Supreme Court and lower courts shall have their offices during good behavior. It's always been understood that a Supreme Court justice has his or her office until the justice retires, is impeached, or dies. And I think to say that the justice can stay on the court in name and salary, but not hear cases, isn't consistent with what we've always understood as the position. But did you know that in 2016, 3 Republican candidates for the presidential nomination, Ben Carson, Rick Perry, and Mike Huckabee, argued for 18-year non-renewable term limits for Supreme Court justices? A recent opinion poll had 77% of the American people favoring term limits for Supreme Court justices. In light of that, I think a constitutional amendment is realistic if people will work for it. Beyond what can be done by statute, beyond what can be done constitutional amendment, I'll ask you to begin thinking about, is it time to start considering the possibility of a new constitution? Does it make sense for us to be governed in the first quarter of the 21st century by a document written in 1787? Think of how very different the world is today from then. I've already touched on then, of course, the protection of the institution of slavery. But the United States at the time was a small country, relatively sparsely populated along the eastern seaboard. The more the Supreme Court says that the Constitution today means, and is limited in meaning, what was intended then, the more absurd it becomes to be governed by that document. Now, you might think, how could we possibly think about drafting a new Constitution at a time when our society is so deeply divided? The polarization I talked about at the beginning. But society was deeply polarized in 1787. The Constitution was ratified by only a handful of votes in several of the states. I imagine we could create a process where there'd be a nonpartisan group of people appointed by the President and Congress take on the task of drafting a new Constitution. Now, there's always going to be the worry, might there be a runaway constitutional convention for either conservative or liberal values? But I would say then that what they propose should be put to the people for a vote, and that would be the check. And my hope would be that the men and women who would be part of that constitutional convention would live up to their responsibility. The 55 men in Philadelphia in 1787 weren't divinely inspired. Many were brilliant, some weren't, but they weren't more brilliant than the people who exist today. Of course, today we have the benefit of all of the experiences since 1787. If there were a new constitution, it would create or preserve many of the things in the current constitution, but it would also deal with issues that the framers of the Constitution never possibly could have imagined or intended. I am not suggesting to you that Constitutional Convention is likely to happen anytime soon. Probably not in my lifetime. But isn't it something to begin thinking about as we confront the problems of American democracy? What if none of this happens? What if we simply continue in the current path? Maybe the country will muddle along. And maybe I'm wrong that the crisis of democracy will come to threaten American democracy. But I'm enormously worried. There is a movement across the world towards authoritarianism. We've seen countries like Turkey and Hungary and India very much turn their back on what had been democratic practices. It would be unacceptable hubris to believe that somehow in this country we'd be immune to the appeal of authoritarianism. Or maybe there will be a point where people in this country will start to question whether what unites us is greater than what divides us. I'll make a bold prediction for you as I stand before you today. I think that if there is a Republican Senate and Republican House, which appears there may be, and of course there'll be a Republican president, and they begin to legislate in a very conservative, aggressive way, we will hear the first serious talk about secession since the Civil War. Again, I am not endorsing it. I am not predicting there will be a secession, but I think we'll begin having that conversation. It was Benjamin Franklin who very famously, at the end of the Constitutional Convention, said, "A republic if you can keep it." And I think the challenge for our generation today is, can we really keep it? Thank you.